think what I'll do is I'll just get started, and if people come in late and have questions, I can just repeat. My ambitious goal is to get through a lot, so I actually have a list to make sure I don't forget anything. So that's just to tell you that it would be very difficult to remember everything that I'm about to say. So, but I want to try to cover everything. And what is everything? So the idea of this talk is to talk about the procedure and the substance of what to expect if your family's land gets brought into court. So there's all sorts of things about property law that I won't be talking about today, but that's basically what I'm going to be talking about. But before I do that, the first thing I want to mention is the land here, because the land here are crown and government lands. And so what that means is generally crown and government lands cannot be brought into court. The resolution of the status of the crown and government lands are considered to be a political question. So that means that you can't generally go to court and have a court make a determination about those lands. So that means for the rule of law, there is no court procedure before damage to crown lands occurs. There is no court procedure that can be done. So in other words, if there's no court procedure, the only thing left for people to do generally is to either do nothing or to put their body in between what they want to protect and what is trying to stop something from being protected. So that's the rule of law. Unfortunately, or fortunately, there are court procedures to deal with injury to crown and government lands, but the problem is that the injury has to occur first. So for example, Pohakuloa, Kuching, and Maxime Kahaleleo yesterday with Native Hawaiian Legal Corporation, their win over Pohakuloa was upheld by the Hawaii Supreme Court. The problem is that's after the damage has already occurred. So to prevent damage from occurring, there is no avenue in the courts. So I just wanted to say that first. Okay, so I'm going to discuss first generally court procedures, what to expect if your family's land gets swept into the court system, and then I'll go into the actual law of real property. So in civil court, the first thing that occurs is when a party wants a court to do something, they file generally what's called a complaint. So usually in a quiet title action, usually the person filing the complaint is a land developer, a realtor, a land speculator. It used to be the plantations. They're the ones that file a complaint, and what they allege is that they are the true owners of the property. So that's the first thing that happens. Now, when a complaint is filed, in order for the court to be able to bring in other people, they have to issue a summons. They summon people to court. And if the person filing the complaint knows who those people are, they have to get somebody to actually serve them with the complaint. But what generally happens is that the person that's filed the complaint doesn't know who those people are. And there's some rules that they're required to do. They have to do research to try to figure out who those people are. And I can tell you from experience, that doesn't always happen, and it's not a very thorough job, because it's basically asking the person who wants the land to identify all of the people who have a claim to it. So there are some minimum requirements that they have to check: Bishop Museum, the state archives, court records for probate cases or any cases that address genealogy. But there's no standards like how thorough do they have to be. So what ends up happening is when they can't identify folks, or it comes to somebody who's passed away 100 years ago, then they ask the court to allow them to serve by publication. And that's, maybe people are familiar with that. You'll see in the newspaper, there'll be somebody versus, and then 100 people who passed away 100 years ago, and it says you have to come to court on this day if you claim an interest in this land or are related to somebody. And so that's serving the summons by publishing it in the newspaper. They're also required, when they do that, to post a notice of the summons somewhere on the property that's easily seen. And I have actually had 2 cases where that didn't happen. And the court will not dismiss the case, but they will order them to repost the notice and to republish it in the newspaper.
Well, we just had that same exact thing happen to us on Kauai, Mark Zuckerberg.
Right.
Yeah.
Right. So these beginning things generally will not end a lawsuit. The courts will generally allow them to do a redo. But if they don't identify the correct people, then that means that whatever the court finally decides isn't valid as to the people who aren't named or aren't correctly served. Okay, so once there's a summons and there's a return day for people who answer the newspaper ad, or if you're personally served, you have 20 days to respond. So generally, unless there's a problem with the actual complaint, you file an answer. And what the answer is you go through each paragraph in the complaint and you either admit the fact as true, you deny the fact as not true, or you say, I deny because I don't have enough information. And that's what the answer is. And then you can also include various defenses that you have that are separate from that. And so defenses could be, sometimes people claim that they own it because they've occupied it for 20 years. That's adverse possession, which I'll get to a little bit later. And a defense to that can be that they didn't occupy, that you deny that they occupied it, but also that even if they did occupy it, that they didn't do it for 20 years, which is required by the statute. So in the answer, you admit or deny everything in their complaint, and then if there are defenses that you have, you would add that after. Okay, so that's how the lawsuit gets started. The next phase of the lawsuit, which is the most important for families, and this is where a lot of lawsuits come to an end and not in a favor of families, is the discovery process. Now, a long time ago, discovery was actually an entirely separate legal process from the lawsuit itself. But about 70 years ago in Hawaii, the courts merged the two. So now once the lawsuit is filed and the answer is filed, then the discovery period starts. And discovery is that any party can ask another party questions. They can ask them to admit particular facts. They can ask for documents. They can ask to inspect land. They can take testimony in the form of a deposition. And so some of those are relatively inexpensive, and some of those are very, very expensive. So if you want to take somebody's testimony, you have to hire a court reporter, and that's very expensive. But you can ask questions to another party. You can ask questions to another party, and that's only the cost of mailing and making Xerox copies of all of the different people you have to send copies of it to. So the problem is that the plaintiff's attorney or the person who's filing the lawsuit, they do this all the time, and the families don't generally do this all the time. And so they will file discovery requests. They'll ask questions of the family, they'll ask for documents and so forth, and as a party you have 30 days to answer. And if you don't, they can use your non-answering against you. And so there is a process. If you don't answer or they don't answer, you have to discuss about why isn't that you haven't answered. And if the parties can't agree on a time to answer these requests, then the party that's seeking the answers can go to court and try to force you to answer. And if you don't answer or they don't answer and the court orders you to, then what the court eventually will do is they will treat your non-answer against you. So whatever the answer might be, if you don't answer, then they will assume that whatever your answer is would be bad for you. And that's where a lot of families get tripped up, because they get overwhelmed. They see the paperwork and they're not familiar with it. They can't afford an attorney, and they don't answer. And the other side just sort of sits back and waits. 6 months goes by, and then they file a motion with the court and said, well, they never answered it, so that must mean they have no evidence. They can't prove that they're related to this land. And so that happens in a lot of cases. The other side will get what's called summary judgment, or they'll get default judgment. So they'll actually have a hearing, and nobody responds to it, nobody shows up, and then they ask the court to hold you in default. And then when that happens, then you can't do anything else in the court proceeding until you ask the court to take the default off of you. So discovery is the most important part of this kind of lawsuit. Now, if you need more time to answer discovery, make sure that you ask for it in writing, because if it ever goes before a judge, you will not believe how many people forget that there was a phone call when you asked for more time. But as long as you have it in writing, it's hard to deny that it happened. But it's very important for the court to show that you are diligently trying to do your best. And if you don't have an attorney, most courts, but not all, most judges will be understanding, and they're actually required to be understanding. And so as long as you are trying to do your best, they will give you more time. Okay, so what is the kind of evidence that you should start gathering if your family's land ends up getting into one of these cases? So the most important thing is to know your genealogy. So I'll use myself as an example. I'm not Hawaiian, I'm Filipino, and I'm white. And my mother's family is very, very large. And some of their family members have like parcels of land in places. And so, like, let's say the auntie passes away, didn't have any children. So one example, my grandmother's mother had a sister who never had any children. She never got married, but for whatever reason, she ended up actually with quite a bit of land. So when she passed away, it would go to her siblings, but none of her siblings were alive. So it goes to the siblings' children. Well, my grandmother had 142 first cousins. And so you can see within one generation, it can get very, very complicated very, very quickly. So actually that's good for a family that wants to keep the land in the family, because if somebody claims that they own that land, they have to show where they got it from. And if you have, just in that one generation, if you have 142 people, well, did they get it from all 142 people? And usually the answer is no. In one case we had with Maui Land and Pine, there were, I think, there were maybe 120 people total, and they supposedly, Baldwin Packers had purchased something from somebody in the 30s from one of these 120 people, and then it turned out actually the person had passed away before they supposedly signed the deed. So Maui Land and Pine ended up not actually having a case, and I'll get to actually that story because it ends up being a little bit sad. So the most important thing is to do your genealogy and to be able to prove. Now, a lot of people have the mistaken belief that you have to prove everything with paper, and that is not true. There are like 20 exceptions to the hearsay rule, and the most important one is that family history is an exception to hearsay. And so let me give you an example. Do you know when you were born?
Yes.
Okay, that would be hearsay, because
okay.
do you actually remember when you were born? So you heard it from your family members, but it's true, right? You know what your birthday is. So that's an example. So in court, you can testify to what your birthday is. It's an exception to hearsay. Well, all of your family history is the same way. You don't need to have documents to prove your family history, but it is very helpful. And you can be sure that the other side will try to find documents to disprove whatever. So you know the song Manuela Boy? You know, like I want to marry Haunani, but don't tell your father, but so that, let me tell you, the other side will look for those kinds of things. So you can be sure if there is a paperwork that says that Haunani isn't your sister because your father's not your father, they'll find it, trust me. They'll find it. No, really, they will, because as soon as you answer, like, it's in their interest to try to bring up any kind of family discord or anything. It's in the interest of the other side to do that. So you can be sure if there's any paperwork against your family, or even if there isn't, they'll still look for it. I had one case, I won't mention the name, but I had one case where the land developer found a death certificate where it basically said that the son was the father and was the witness for his own death. And it was just I think it was just a recording error of the Department of Health 80 years ago. But it's those kinds of small little mistakes that they then use to try to defeat your genealogy. So it's very important that you get your genealogy together, and to the extent that you do have paperwork or you can get paperwork, to do that. So Department of Health, birth certificates, death certificates, marriage certificates, that's a place to go. The archives, census records from the Kingdom period are a great source of information, although I heard recently some of the census records from one of the censuses disappeared and the archives is looking for it. So those have been microfilmed, and I think UH has copies. So if that kind of thing happens where you can't get a copy of the original from the archive, there are other ways of being able to show the courts that it exists. So all of those places, I know that the LDS Church has taken photographs of certain records, and that can sometimes be helpful. The Mission House museums, different museums, sometimes have paperwork of something that might be useful. So that as soon as you know that your family's land is in a lawsuit, if you don't have your genealogy all together, the time to start doing that is as soon as you know about the lawsuit, because the more time you have, that gives you more time to look for things and to talk to folks as well. So, okay. The next thing that happens in a court procedure is as the discovery period comes to an end or comes near an end, the court generally is required to have the parties come to a settlement conference, and you're required to do it. And if you don't come, you can be punished by the other side. I mean, you can be found in default if you don't come. So you do have to go to it. There may be nothing to settle, but you still have to come, and you still have to, in good faith, entertain the court wanting to try to either settle the case or narrow the issues. So in that Maui Land and Pine case that I had long ago, the court used a settlement conference to have everybody agree on what the genealogy was. And so it happened that I actually didn't represent anybody in the family. I actually represented, in the 50s, the family had a neighbor who was also Hawaiian, who did a bunch of automobile work, and the family didn't want him to just do it for free. So they said, the one guy said, "Oh, well, I'll sign my 100th interest in this lot to you." And then he passed away, and then actually I represented his kids, who are all, at the time, were very old. They've all passed away since. And so they used the settlement conference to have everybody agree on what the genealogy was. And because everybody else was family, it was really easy, because nobody had a dispute. And the people, of course, Maui Land and Pine, what are they going to say? And then, of course, the six people I represented, they had no dispute because it wasn't their family. So they whatever the family agrees to. And so by doing that, they avoided having to have a trial as to the genealogy. So sometimes a settlement conference can be helpful because it can limit all of the work that you'll have to do after it. But it's very important that you go, because if you don't go to it, the court will use that against you. Okay, so then there's a trial. So the trial is where everybody puts on their evidence. And I should actually mention here, one of the things in a quiet title action that you can ask for is a jury demand. Now, I have to tell you, it's very rare to have a jury trial for a quiet title action. In fact, I think I'm one of 5 people that I know that have taken a quiet title action to a jury trial. It's very, very unusual. And if you are not represented by an attorney, I would think very hard before doing a jury demand. And the reason why is because when a judge hears the evidence, if you make mistakes, the judge is assumed that he or she can just disregard anything that you make a mistake on. If you make a mistake in front of a jury, the jury can't disregard it, and the court will have to make instructions to the jury that you did something wrong. And if you've ever been on a jury, right, like at some point, if you do enough wrong things, all the jury's going to remember is you don't know what you're doing, you're not trustworthy. So it can be a jury demand is a very powerful weapon, but it's also a very dangerous one. So if you are not represented by an attorney, you should probably talk to an attorney, if you know one, about whether or not it's a good idea to make jury demand. But if you do have an attorney who does jury trials, then you should definitely strongly consider it. Okay, so then there's a trial. So the trial is where everybody puts on their evidence. So the person who filed the complaint generally has the burden to prove that they have title, and then the people who the complaint has been filed against, then they have the chance to prove that they have title and to prove that the person who filed the complaint doesn't have title. So it's their turn, then your turn, then their turn again, and depending on what the facts are, you might have a second chance at saying more things. And so for bringing in evidence, if the parties can't agree to bring in the evidence, then you have to have a live witness bring in all of the evidence. So government records that are certified, any live witness can do that. Birth certificates, death certificates, marriage certificates, stuff from the state archive, that can come in by anybody if it's a government record. If it's not a government record, if it's something from like the LDS church or from some other private thing, then it's the person who gets it from them is the one that has to bring it in. And then of course, whoever has knowledge about your family genealogy would be your witnesses. So what the other side will normally do is hire a professional genealogist to bring up all this stuff about what isn't true or what they're claiming isn't true about your family genealogy. And so, things that you can do is attack the credibility of the genealogist. And so, of course, the easiest one is how much are you getting paid? And that's the easiest one, right? Because of course, if someone's getting paid, they might say whatever. So when the trial is done, if the judge is the one that's hearing the case, generally what the judge will do is will say they want the parties to present proposed findings of fact about what the truth is. If it's a jury, then there will be instructions to the jury, and then the jury will get to decide what the truth is. That's the role of the jury when there's a jury, is to decide what the facts are, and the judge decides what the law is. And so the trial ends with either the jury or the judge giving a verdict of who has an interest in this. So some cases, it can be the person who filed the complaint is the only one with an interest. Sometimes it can be the family defending are the only ones with the interest, and sometimes it can be a mix of the two. It can get very complicated. So in that Maui Land and Pine case I was mentioning, they turned out that they didn't have any interest because the deed that they had was signed by somebody who had passed away 10 years before they actually signed the deed. So what Maui Land and Pine did, they were desperate at the time, this was before they had no money, they were desperate at the time to stay in this. They actually found 2 cousins that were on bad terms with the rest of the family, and those 2 cousins sold their interest to Maui Land and Pine, and boom, they were back in the lawsuit. So that's the other very important thing about this, is that when you have family land that's drawn into a lawsuit, the family needs to come together and talk about what's going on, because if you don't settle that stuff, you can be sure that the other side is going to help you settle it, and it's probably not going to be in a way that anybody's going to like. So that's the other thing. Okay, so then at the end of the case, there will be a judgment. And if there were if there were mistakes, if the judge made mistakes about what the law is or the procedure, or there were just facts that were clearly wrong, you can file an appeal to the appellate courts to challenge those things. It's very difficult to challenge the factual findings of a court. It's a lot easier to challenge the legal findings of a court. So the Pohakuloa case, for example, the state challenged the findings that Judge Chang made, that the state has basically allowed all sorts of bad things to happen at Pohakuloa. And the Supreme Court denied that part of the appeal because they said, it's up to the judge. The judge decided there's evidence to support the judge's findings. The state really has made a mess of, allowed the U.S. military to make a mess of Pohakuloa. So the Supreme Court in their case basically said you can't challenge that. The legal stuff is much easier to do because, you know, any judge can decide what the law is. So if the trial court judge is wrong about the law, the appellate court gets a new crack at it. They don't give any deference to the trial court about the law. So if the trial court doesn't find the right law, you can always appeal it. Okay, so that's court procedure. Good. We have just enough time now to go on to the substance of the law of real property. Sorry, there's so much stuff here. I want to make sure that I get it. So, okay. So real property. So this is this system of dealing with the control of land is primarily based on Anglo-American concepts of land use and land control. And in that system, possession is 9/10 of the law. If you are possessing land, you are considered to be the true owner, except as to anybody who has superior title, which means the true owner. So one question that's asked a lot in West Maui is, Maui Land and Pine supposedly owns portions of all of the ditches that divert the water out of Honokohau and Honokowai streams and Honolua stream. And the question is, well, why don't they just challenge it? Well, because the only people who can challenge that under the system are people who have superior title, meaning the true owners. So if it's not your family's land, you generally can't challenge Maui Land and Pine or whoever claiming that they own a parcel of land, especially if they're using it. So that's one of the concepts, that title is relative, land title is relative in the Western system. But in terms of being able to go into court to challenge somebody's ownership of land, you have to have superior title. If you don't have superior title, you can't maintain an action against somebody who's occupying land and claiming that they have a right to it. So that's why it's very important to look at the LCAs, the Land Commission Awards, and to look at other kingdom grants of land, and to start from there to determine ownership. That's why it's so important, because those families generally have the highest claim to land. Okay. In English law, up until the 1600s, the control of land was done through the feudal land tenure. And so what that meant was the king would give either military or a monastery or some person that was powerful use of land. And there would be all these conditions. They had to give money to the king, they had to provide service to the king, there would be all of these conditions. And then the person that got the land could then take a portion of what they were given and allow other people to use it, and it would go down the system. But it was like, okay, well, if I have to give the king 5 days of service, I'll chop up this land into 5, and each of you have to give the king one of those days of service, plus you have to pay me some money or give me some portion of the harvest, that kind of thing. That's how it worked. And at any time, the king could basically take back that grant of land and then everybody under that system would basically lose their thing. So when the missionaries and when the American businessmen came to Hawaii, they thought, well, what the Hawaiians are doing obviously is like what the English were doing 800 years ago. And so although it actually wasn't the way land was used in Hawaii was not how the English system was during the feudal period. That was the fantasy of missionaries and of businessmen. And so they sold this concept, and as soon as they could, started working it into the law, so that suddenly the legal system that was created started looking a lot like referring to the Hawaiian pre-American legal system as a feudal system. I'm sure maybe you've heard that, oh, the Hawaiians had a feudal system, and actually they didn't. But it had some consequences for looking at it that way, and that was when the Mahele came around to free Hawaiians from their feudal vassalage, came up with the freehold system, which is what the LCA awards and the royal patents eventually did, which was to create fee simple absolute allodial type titles. So allodial is a term that actually refers to the opposite of feudal. So feudal is well, you have control of land, but you have all of these obligations, either money or service, to a higher lord. And a allodial title cuts that off. When you get the ownership of that land, you no longer have any obligation to the king or to anybody in the pyramid going upstream. And so what that did was that there was no, by controlling the land or having ownership of it, you no longer had any recognizable obligation to the king or to your ali'i nui or so forth. And of course, as we know in Hawaii, even though there was all of that paperwork, actually that's not really what occurred in practice anyways. And is one of the reasons why courts today continue to recognize traditional and customary practices primarily on undeveloped land for that reason. But it is important to understand that. So freehold or allodial title, sorry, I want to make sure I get all of this, can be transferred two ways. One is during life and one is after life. And the way that lifetime transfers generally occur are by what are called warranty deeds and quitclaim deeds. So a warranty deed, a deed is a transfer from a grantor to a grantee, from a conveyor to a conveyee, or a vendor to a vendee. And a warranty deed conveys some interest in land. It can be someone's entire interest in land, it could be smaller than the entire interest, it can be a part of the interest, it can be for a period of time. But the difference between a warranty deed and a quitclaim deed is a warranty deed, the person transferring the land warrants 6 things. Season, which is that they actually are the owner, that they warrant that they have the right to convey the land, that they warrant that there are no encumbrances on the land, that there's no liens, that there's no mortgages, nothing like that. That they also warrant that there's nobody on the land that shouldn't be on the land. That's quiet enjoyment. And that they warrant that if any of these things are wrong, that they will basically do whatever it takes to fix that. And then also just further assurances, which is a legal term. But those are the 6 things that when someone transfers land through a warranty deed, that is what they're warranting. The other thing is a quitclaim deed, and that doesn't have any of the warrants. So the quitclaim deed, so if your family's land ends up in court, you'll probably see at least one quitclaim deed on the other side's claim of title, because the quitclaim deed doesn't warrant that they are the owner of the property, that they have the right to convey it, that there aren't any encumbrances or anything. They're just basically saying, if I have any land in whatever I'm identifying as the land, I'm transferring it, and I'm not making any warranties that I own it or that there's any quiet enjoyment or anything. So you'll see when family land is brought into court, the other side will generally have at least one quitclaim deed in their chain of title. That's why they're quieting the title, because they have not been given warranties that they actually got anything. Okay. Transfers after death. So this is more important for family land than it is for the other kinds. So land is transferred after death by wills. If somebody didn't make a will, then it's transferred through what's called intestate succession, and that's by operation of law. And so the law of intestate succession that occurs at the time of death. So there's a couple of little things that we do have some time to talk about that occur. So one thing is that the law of intestate succession up until the 1940s had some sexist requirements where men or legitimacy of somebody would determine whether or not they inherited. And so that under current law is not valid. And so then the question is, well, if someone passed away when the legitimacy issue was around, is it enforceable? Because it's basically illegal now to discriminate against somebody because their parents weren't married when they were born. And so the courts have a test, is that the only time that the courts will enforce the inheritancy laws that discriminated against illegitimate children is if somebody relied on it at that time through a warranty deed. And if they didn't, then you can't argue it now. So if somebody says, oh, well, that's not valid because the person was illegitimate, the court's going to say, well, in your chain of title, did somebody rely on that? And if the answer is no, then you can't rely on the person can't rely on it in court. So it's a very narrow exception, but even though it's a narrow exception, attorneys that represent the land developers, land speculators, and the plantations, they'll still bring it up because it's like a way of discrediting or causing, questioning whether or not somebody's in your genealogy. It's just another way of sowing confusion. And I think sometimes also embarrassing because I think they think that, oh, it's somehow embarrassing if your parents weren't married when you were born. I don't know, but I do see it. It's relatively, it's just a way to throw a family's genealogy into question. So it does come up, but it's a very narrow exception and it's just something to be aware of. Okay, one other way of transferring title is trusts. And I think maybe everybody's probably most familiar with the ali'i trusts. So there's two kinds of trusts. One trust is a trust that doesn't have a charitable intention. And if it doesn't have a charitable intention, then a trust has to terminate within 21 years after some life in being. It's called the rule against perpetuities. And so that's why Campbell Estate, for example, was a trust. And when the last 21 years after the last person that was alive when the trust was established passed away, the trust ended and turned into a corporation, or some people, I guess, just wanted the money and other people. So that's what happened to Campbell Estate. It wasn't a charitable trust, it was a private trust. A bunch of land was put into it, and at 21 years after the last person who was alive when the trust was created passed away, it terminated. If the trust is a charitable trust, there is no limitation. So that's why Kamehameha Schools still exists, Lunalilo Trust, Queen Liliuokalani Trust. All of those ali'i trusts exist because they were created, the remainder of the trust was created to serve a charitable purpose. And so they'll live on forever. So like Queen's Hospital used to be a trust, but they were allowed, and they could have actually existed forever as a trust, but they asked the courts to allow them to stop being a trust and instead to be a corporation because I can't tell you why. Those are the kinds of trusts. So land can be transferred into a trust. If it has a charitable purpose, it can go on forever. If it doesn't have a charitable purpose, it has to terminate within 21 years of some life and being. So when they make those trusts, they try to identify some group of people who are very young so that they can live a very long life, and then you plus 21. If you pick somebody who's going to pass away the next year, then it's only going to last for 21 years. So that's trust. So that's the way that transfers can occur. So if your family's land is subject to a case, you're usually dealing, for the most part, with intestate succession. Most family members did not execute a will, and it didn't go through probate. But there are times when someone did execute a will and they did go through probate. And so this is very important. It is possible for somebody to have an interest by their family line through many parcels of land. And it's also possible that when they pass away, the family, for whatever reason, bank reasons or some reason, only takes one parcel into court and to determine who are the heirs. So some people are like, oh, but they didn't, now this land that's in there wasn't in there, and then the land developer is saying, oh, well, that's because they didn't own it. That's not true. The court can open up 100 probate cases for each individual piece of land. You're not required to resolve someone's entire estate in a probate case. The only thing that it means is that the court has made a determination at that point in time who the heirs are. So does it mean that if they made a mistake 50 years ago when they did that you can't address that in the current case? No, it doesn't. You can always address it. It just means that the other side will potentially, I call it the Manuela Boy defense, the other side will try to use that to try to muddy the waters or try to claim that your genealogy isn't your genealogy. So it's not the end of the world. It just means that it can be used against you. Okay, adverse possession. Adverse possession is basically how the plantations obtained control over so much vast areas of land. That's one way. The other way is by getting deeds. And as I mentioned in my Maui Land and Pine case, had somebody who had passed away 10 years before the deed was signed. And so the history of adverse possession. So adverse possession was created in English law for a very specific and narrow purpose. So in England, 1,000 years ago, they had this thing called Magna Carta, and they did this process of where they surveyed all of the lands to determine who was given control over what land. And in some ways it was like the Mahele, but in a lot of ways it wasn't. But this whole fantasy of projecting English history onto Hawaiians and creating this feudal past with evil tyrants was part of this process. So the English had something, in some ways it was like the Mahele, but wasn't 1,000 years ago. Well, any time that land was transferred, it would be done by a deed, and the person who got the land would then have all of the previous deeds going back to the Doomsday Book, to the original survey. And so, of course, land in England didn't transfer very frequently. So when there would be these transfers of lands, you would have to have somebody go through and make sure all of the deeds were written in the correct way. People made mistakes. Everything was done by hand. It was all done in cursive. So adverse possession became a way to cure some mistake that may have happened 100, 200 years ago that nobody caught. And land is very infrequently transferred. And it was basically a way to correct very narrow mistakes. I mean, it was not done so like, oh, I'm going to move into somebody's castle and then 5 years later or 10 years later claim adverse possession. Oh, it's mine, sorry, you were in France, ha ha ha. That is not how it was used in England. It was used because somebody 100 years ago didn't catch, they spelled the name wrong, or they said that it was used, that the description of the land was somehow wrong. That was what adverse possession was used for. It was to basically correct mistakes in deeds where everybody agreed on who the owner was. Well, in America, it worked a little bit differently because there were tons of land that was being stolen left and right from Indians, from Native Americans. And so adverse possession became this totally other thing, which was I'm going to build a giant fence around as much land as I can, and if I can keep people off of it for 5 or 10 years, then it's mine. So that's the American version of adverse possession, and that's what was brought to Hawaii in the 1870s. It was used primarily by the plantations to take land from Hawaiians. That's what adverse possession was created for, and that's what it was used for. Just like the mortgage law that was adopted in the 1870s was created to remove foreclosure procedures from the courts, because there was a belief that Hawaiians would never allow kuleana land to be foreclosed and given to a bank or given to the plantations. So the plantations were able to secure a law which removed the foreclosure process from the courts entirely, and that remained on the books until 2012. And actually it still remains on the books as long as the land isn't used as residential purposes. Non-judicial foreclosures still can occur. Hawaii is like the only place in the world where someone can do a foreclosure and not go to court. And that was very successfully used by the plantations to take control of land. Okay, I know we're going to run out of time and I haven't really got into it. So adverse possession was limited. In the 60s and the 70s, there was a big push to end adverse possession. There really is no reason for it. So to push to end it, well, it was like going to be the end of the world. Communism was going to appear in Hawaii. It was like this huge dramatic, the end of the world would come if adverse possession couldn't continue. So the compromise in 1978 was that instead of it being 10 years and unlimited tracts of land, it was limited to 5 acres, and the person claiming adverse possession had to have it for 20 years, and they could only claim adverse possession once. So that's the limitation to that. Okay, so what are the elements? In order to prove adverse possession under the American system, you have to prove that your possession of the land was continuous, actual, open and notorious, hostile, exclusive, and under color of title. So this is why it's so important for people who claim title under plantations to even have a deed that a dead person had signed. Because as long as they have that, then they can, as an alternative, claim adverse possession. Well, we thought that we were the owner, and then they have to prove continuous, actual, open, notorious, hostile, and exclusive possession. So that's why sometimes you think like, well, everybody knew that this guy passed away. What's the point of having a dead person sign a deed? And that's for the backup of adverse possession. Because once you have a deed, doesn't matter how bogus it is, if you can claim that you thought you had title, that's enough to be able to prove the rest of it. So that's the danger of adverse possession. It does come up. There is a way that Hawaiians actually can use adverse possession as a weapon backward. If you are in possession of your land, one of the defenses to somebody quieting title is, okay, you may have something on paper, but my family's been here for, since the Mahele, we've been here. So if we actually didn't have title for whatever your bullshit reason is, we actually do have it through adverse possession. So it is common for families to claim adverse possession as a defense if they've been on the land. Okay, I know we're running out of time, and I did want to allow anybody who asks questions to ask, but I want to mention one more thing. Sometimes you hear land court. I know, especially for neighbor island families, land court is awful because all land court cases are resolved in Honolulu at the courthouse on Punch Bowl. But what is land court? Okay, land court is also known as the Torrens land registration system. So in the middle of the 1800s in Australia, the settlers were having a problem about like who's the owner of the land. Not because they weren't very successful of pushing the natives off the land. They were actually very successful at that in certain places. Their problem was that they were trying to steal the land from each other. And so they're like, oh, well, adverse possession can't work here because then, it's like people selling land they don't have and people are making tons of money. So they invented this system based on sailing ship registration. So in the sailing ship world, you couldn't adversely possess a ship. there would be a registry somewhere that said you are the owner, and you would get a certificate of ownership, like a car. A car, for example, follows that same system. So they created the Torrens registration system to be like how you own a car with a certificate of title. You lose the title, you're still the owner of the car. You have to go to the clerk and get a duplicate certificate. So that's how the land court system works. It's the exact same thing, but the process by doing that is still a quiet title process. It just goes through the land court. And the only difference between a land court title and a non-land court title is that land court, which was adopted in Hawaii in 1903, is not subject to adverse possession. So if you see how this works, the whole land court system, the only reason why land is in land court is to be able to sell land, to make it marketable. That's the only reason why you would put land in land court. So for example, Ka'anapali Resort was only built because that whole area was put through land court. The bank said, we're not going to lend money to the hotels to build hotels if some Hawaiian 30 years from now can come into court and claim that they own it. So where you will find most land court cases are resort developments, condos, those areas. But that's the whole point of land court, is there's no adverse possession there. The only way that you can get ownership is if you go and you file with the land court the deed saying that ownership is being transferred and it's been recorded in the parcel. So that's, I think I've covered everything. If anybody has any questions about procedure or, yes?
Just a clarification on what did hostile mean when that was one of the...
Oh, so hostile means is if you claim ownership of land, that you exclude other people, or if somebody's doing something against what your claim of ownership is, that you take action to exclude them or to stop them from doing something. So, if you permit somebody to come onto your land to do something, they can't claim they can't prove hostile, because if you permit them onto the land, then they can never meet the hostile requirement. Yeah. Yes.
There's a whole bunch of cases coming up with the sugarcane lands all flooded in the sea brewer.
Right.
And so we're trying to figure out the issue of life estate and co-tenant issue.
Okay, so a life estate is a type of freehold estate. This is one of the things I mentioned in a general way, but not specifically. So a life estate, you can transfer during your life, you can transfer your interest in land for the life of yourself or the life of somebody else. So for example, let's say I have a piece of land, and as long as I'm alive, I want my second wife to be the one to, or second husband, to be the one to live there. And then once I pass away, then it'll go to my kids or whoever it is by my will or my law. I can issue a deed that gives a life estate to whoever that person is in that land, and then when I pass away, that interest reverts back to me and then goes through the normal intestate succession. So life estate only is valid for as long as there is whatever the life in being is. Yes?
Say like in Kanaka Hawaii case, called Sunshine now, so they basically funneled all titles into Monica Mallet's first claim, tenant in severalty.
Okay.
Now she's going as a LLC.
Okay, yeah, I don't know the specifics of that particular case, but tenants by severalty is basically when you're a sole owner of a land. That's what that means. Yes.
Can you address this land here and the road that goes on it? The guy came with his road patent, said that's all his land, and the road was illegally built there.
So I don't know about royal patents. I do know that most of the land here is crown and government land. And I mentioned this at the very beginning, that they say, oh, the rule of law, blah, blah, blah. Crown and government lands cannot be addressed directly in the courts. The courts have ruled that resolution of crown and government lands are a political question, which means that the courts cannot deal with that. So that means that if you want to protect land from being injured, before it's injured, courts are not the remedy, because the courts have said that they decline or they are unable to address those issues. So that is the rule of law. So it's like, oh, well, the rule of law, well, there's no court process to address the unresolved claims of the Hawaiian people to Crown and government lands. However, the problem is there is a court process if there is damage or injury to lands. That's what happened with the Pohakuloa case, but that's after the fact. So I mean and it's not a full issue either. So and then to address the royal patent, I'm not sure. I didn't know that there was any land commission awards around here, but if there is, then that's another separate issue. Okay.
I just wanted to comment. I've done genealogy for a long time, but attend your local family history centers at the Mormon Church. You don't have to be a member. Volunteers will help you, and they have the one in Kona is they've amassed a large amount of films that you can look at, and very helpful with computer. You can set you up with accounts, and you'll have your own account with the church program. And you can also link in with Ancestry.com from there. But that you gotta pay separate. The church site is free. You don't have to be a member, and you have access to all the church records. So when it comes to genealogy, it's very important that you have all of this information, and go to your family history centers. In Hilo is the one at the family history center is on the state at the state center on Kino'ole, I believe, and then the one in Kona is behind McDonald's Hamburger Hill. So folks attend those, and they're open usually. The one in Hilo is open every day. Yulene Kalima heads that. Wonderful genealogist. And the one in Hilo, they have all the books. That's the one thing about Hilo. Plenty books of family genealogies, and it would be really nice if you guys could attend. You don't have to be a member. They're not going to send the missionaries on you for joining the church, so no need to worry about that.
But if you want to.
But that's all I have to say.
Yeah. And so I also want to say one thing too, and this is true for all land cases, is that, you know, when land cases come up and you start doing genealogy, you really do have to make space in your heart for your family and stuff that you may not have known, or difficult things that your family didn't talk about, because all of that stuff comes up, and if you don't make space in your heart for it, it will be used against you. So it is very, very important that you really make a big space for everything that you're going to be receiving, because if you don't receive it, it will be used against you. So it's very, very important with genealogy. Okay, last question, because I think I'm taking the next person's time.
It sounds like Kuleana and adverse possession, Kuleana, is kind of similar. Can you explain the difference?
So Kuleana lands are lands that were subject to land commission awards, and then if the tax was paid or there was no tax, then a royal patent would be issued. Adverse possession is one of the ways that the plantations and others have tried to use legal processes to take those lands. So, okay, thank you very much. Sorry we went over. So thank you.